Okay, welcome everyone. Hopefully people can hear me. My name's Kevin Mosher, and I'm an HR attorney. I think there's even a bio, maybe in the next page. But anyway, I'm an HR attorney and labor and employment law specialist, certified by the MSBA, partner at the law firm Thompson Co. Cousins and Irons, and up here in our Minnesota office. And I'm excited to, at least for some part of today, for this next hour, not talk about coronavirus, though I think we are going to end up, in fact, I know we're going to, since I'm in charge of me talking, I guess. I'll be talking about coronavirus and the impact on wage and hour law. Obviously, 4 months ago when I put this on the agenda for our webinar series, I did not, and I had no, anticipation for, what is going on in the world today. But I think there's some absolute relevance. If you are an employer who is dealing with layoffs, you probably are, temporarily or maybe even permanent terminations, or some people like to call them furloughs, though I hate that term. You need to understand wage and hour law. It's absolutely critical for understanding it with your non-exempt employees and your exempt employees as well. A little bit more complicated with the exempt employees. So we are going to talk about that. Some of these slides, we'll talk about it in between these slides, how it can impact you. But so today, this month, March 2020, this is fundamentals of wage and hour. Next month is going to be more complicated issues around wage and hour, and so we're going to dive much deeper into these basic general topic areas. I want to, my goal today is to lay a foundation for you, review on, a lot of these for many of you, but I want to lay a foundation of understanding wage and hour laws so that we can really dive deeply into some really complicated areas. And I will say with the coronavirus, it is definitely a complicated area of time. If you are in HR, what's at all. So this is me. This is my very quick bio, and so I'm excited to do the webinar. And if you are not a member, I know most of you on the call here are likely members of the MyHR Genius program. If you're not, you might want to seriously consider it, especially if you're doing layoffs or have any coronavirus-related questions. I've been on hundreds of calls in the last couple of weeks on this topic, and it's all covered by the membership. So $79 a month for the base membership. So if you're not, you might want to think about being a member and getting some serious support, especially on all your legal issues around the coronavirus. But obviously, anything else having to do with HR is fair game as well. And then with the program, you get a number of services, including the hotline. All you can call and use on the hotline, emails and phone calls. Obviously, webinars, updates. On the updates, if it's not in, for those of you on the program, if it's not in your inbox now, it will be in very near future, probably by the end of this webinar. An entire primer that we put together and on the new law that just passed yesterday and was signed passed by the Senate and signed by President Trump yesterday, dealing with amendments to the FMLA and dealing with a new paid sick leave law. So there is, as of the beginning of April, in 15 days, starting from yesterday, there is going to be a paid sick leave that is going to apply to anybody for a number of reasons. There are 6 criteria under that sick leave. Anyway, everybody on this call needs to understand it. And also now every employer with less than 500 employees is now covered by the FMLA. So congratulations. If you're a smaller employer, you now need to, and you've been ignoring the FMLA all this time because you're under 50 employees, that's no longer the case. You don't have the luxury any longer of ignoring the FMLA. It now covers you, or will in 14 days. So there's a lot. If you're on the program, you're going to get, and you're on the email list, you're going to get an update, an entire primer on coronavirus. If you're on the program, definitely call. Let's talk about strategies. There's a lot to this law that's going to impact employers on expanded FMLA, paid FMLA, as well as paid sick leave, 80 hours for full-time employees. So there's a lot to it. But again, it's tangential only to this webinar. If you have any questions and you want to be on the program, that's great. We'd love to have you. If you have any questions, you're on the program, definitely reach out to me or anybody else on the MyHR Genius team, and we'll be happy, or at Thompson Co., and we'll be happy to help you. We also I will say this finally, on the Thompson Co. website, we have a COVID-19 response team. And I would encourage anybody, there's resources, especially resources on Louisiana, Texas, Minnesota, and California executive orders. There's analysis on there, as well as other resources, the tips that we've been putting out on dealing with mass layoffs and questions about anything having to do with COVID-19. So I would encourage you to go to the thompsonco.com website or to the myhrgenius.co website for a lot more information on this, or obviously call. Okay, the FLSA. So this is going to be federal. There's obviously a lot that has to do with state laws, and the states. So the federal sets a minimum bar on all of this. So what is the FLSA, right? So this is the federal law. It's going to cover everybody. There are some exemptions. We'll get into that a little bit later, but what does it do? It covers most every employer. You've got to be engaged in interstate commerce. The Department of Labor defines today, it's changed the definition over the years, the decades that the FLSA has been in place, but it defines interstate commerce as if you've got if you're engaging in interstate commerce and you've got over $500,000 in sales. If you're under that, there's an argument to be made that you're not significantly engaging in interstate commerce, so you might be able to be exempt from this law, but then you might not be exempt from state laws. And a lot of states have their own like minimum wage laws and overtime laws and that sort of thing. So not every state does. There are a lot of states down, particularly in the South, that don't have their own state laws. But most states, have something at least setting a minimum wage, for employers and employees in that state. So what is the minimum wage? Well, right now, for all employers in the United States, it's $7.25 minimum. If you're covered by the federal law. Obviously, a lot of states, and we've talked about this over the years as we've been tracking this, a lot of states have higher minimum wages. So you got to go with the higher, right? So in Minnesota, we have a higher wage. In California, there's a higher wage. Illinois, there's a lot of states have higher minimum wages. Washington, and then a lot of cities also have higher minimum wages. And so if you have employees working in those jurisdictions, you're going to need to understand those local laws. But at the federal level, if there's no state, there's no local law. At the federal level, minimum wage $7.25. It really hasn't changed. Trying to remember when it last changed. I want to say 2003, but I might be a little off on that. Anyway, it doesn't really matter when it changed. It's been like this for a long time. It's completely obsolete, which is why states and cities have been stepping in to raise the minimum wage. So anyway, $7.25. Maybe with coronavirus and all the many layoffs that are going to occur, maybe you'll be able to pay people minimum wage to do jobs. But for the most part, in the economy that we've had since the Great Recession, which again probably is not the economy we have now going forward for the foreseeable future, but since the Great Recession, it's been pretty hard to recruit people at minimum wage to do jobs that are anything but entirely menial. And what does the FLSA also do? Restricts, so we've got the child protection, child labor piece, so it restricts work for children under the age of 18. It requires that you pay overtime. Obviously, there's exemptions. We talk about people who are exempt from it all the time, especially the white-collar rules around exemptions. But as a base rule, everybody needs to be paid overtime. And what is overtime? Overtime is work, quote, actual work, over 40 hours in a work week, okay? And we'll get into those definitions in a minute here. It also requires that you track time and we'll talk about what it means to track time, but it requires that you track time for all employees, again, unless they're exempt. And you have the burden of proving the exemption, not the employee. All right, so you got to meet some specific criteria. That criteria, depending on what the criteria is, has been around in many ways, for some of them, decades and decades since this law went into effect. So we need to understand, if we're going to not pay somebody overtime, if we're not going to pay them minimum wage, if we're not going to track their time, we need to understand whether they hit the exemption. And then it requires notice to employees that normally comes in your laminated poster. So every poster I've ever seen that is put out by private companies, every poster that I've ever seen has the proper notice notifying you of all the employees of all the rights under the FLSA. So the FLSA is one of those notice provisions that's on a poster. And by the way, in case I forget it, there's also a notice requirement under the new coronavirus law that just was passed yesterday. So your posters will all need to be updated. You'll need to get notice, and that notice will be available next week from the Department of Labor. So I think my plan here is just to pepper little coronavirus new laws and everything. And we also, I will say before I forget, we will also be doing an emergency, I'm doing that later this afternoon, an emergency webinar that I'm going to tape record and then send out to people on the My HR Genius program on the new coronavirus COVID-19 law. So just if you want to have an idea of what my life has looked like the last 24 hours, I think I just laid out my schedule, learning that law and putting out a bunch of communications on it. So, and obviously doing this webinar, which is really exciting. Okay, so what are the key terms? We need to understand some key terms under the FLSA. Okay, to employ. To employ means to suffer or permit to work. I've said this before. If you've been listening to me for years doing these webinars, you know that is my favorite definition in all of federal law. So really exciting. I love the idea that the federal government considers employment to be suffering or permitting to work. It's an important definition to understand, actually. So suffering, yeah, that's funny. Okay, so somebody does work for you, they're employed. To permit to work, sometimes people, it's come up for me over the years, sometimes people will come in and they'll do work for companies, and the companies will just allow it. And there might not be, they might not do the I-9. They might not be a pure independent contractor. They, but the company knows that they're doing work on their behalf. Well, if that's the case, boom, that person's an employee. I don't care if you didn't do the I-9, if you didn't do orientation or onboarding, which is what we call it now, or intake paperwork, all that. I don't care if the person did some work for you. It could have been for an hour. It could have been for a day. It could have been for 10 years. You're allowing them to work on your behalf. They're entitled to protections and minimum wage and overtime and all that sort of thing. You got to track all that. They're employees. And that sounds simple. It sounds simple to say, but it comes up every once in a while where you're just like, well, I didn't really hire the person, but yeah, they just went to the yard and they started picking up some stuff. They came in with their cousin and they just started doing this, that, or the other. You got to pay them. And even if you don't have a social security number for them, or if they're illegal, you got to pay them. Figure out the illegal part later, but they're entitled to wages. And even illegal workers are entitled to wages, full wages. You can get sued and tagged under this law for not paying wages to illegal workers. So we got to understand that's what employment is. Suffer or permits work. What is a work week? A work week is any 7-day period that you choose. It could be Saturday to Sunday to Saturday. It could be Friday to Thursday. It could be Wednesday to Tuesday. You define what the work week is. If the person works more than 40 hours in that designated period of time, they're going to be entitled to overtime. It's important that you understand the work week, that your work week is defined. A lot of these things, especially if you're here in Minnesota and we've got this new wage theft law, and New Jersey also has a new wage theft law, which is very similar to, akin to what Minnesota did. You've got to tell employees new employees, you now have to fill out a complicated, complex form where you notify them of all these things: the estimated hours worked, their regular rate of pay, whether they're exempt or they're going to get paid overtime, what their job is, what the work week is, all these sorts of things. A lot of this is already covered under the federal law, but now we need to provide a lot of information to employees at the front end, and then also for current employees that are already currently employed after the law took effect. If their if any of these terms or conditions change, we have to provide them with the notice as well. A lot of things that we forget about when we're dealing with emergency coronavirus issues. There's still all these laws are still in play, including HIPAA, including ADA. Anyway, again, I'm going to apologize for going off on these coronavirus tangents here and there. But I suspect a lot of you are dealing with these, and have been dealing with these for the last week or two. And so hopefully it's helpful that I go off on these tangents. We need to understand what exemptions are. We'll lay out what the exemptions are later in the webinar here. Deductions from pay. You can't just go and deduct from somebody's wages. There's federal prohibitions on it. There's state prohibitions on it. As a general rule, there are only certain deductions that are allowed to take from employees' wages, and you can pretty much never dip wages below the minimum wage. I don't care if somebody signs off on an authorization saying that they stole from you and they want to pay the money back. You can't dip them below minimum wage. You can't make a deduction below minimum wage. There are state laws that step in here on this issue as well. Minnesota, for example, I think says not just minimum wage, but 45 times minimum wage. So you can't. The employee gross wages, obviously gross before taxes and everything, cannot dip below minimum wage. We can't do that. Very, very limited circumstances. You need to talk to a lawyer if you're going to do it below that. Wages. We need to understand what wages are. Wages are tender accepted in the United States. There are situations where we can compensate employees. Or at least we can claim a credit for items for providing housing, for example. Again, very rare these days, but there are certain jobs where the employers are providing housing and they get some sort of credit. We need to understand tips. Tips is a form of wages, but the difference with tips is that the tips are entirely controlled by the employee. Employers should not be controlling tips. Employees should be controlling tips. That's compensation for employees. Under federal law, if it's a tipped type of job, and not every job is a tipped type of job, it has to be a direct service related job, and then you're receiving the gratuity from the customer, the tips can be counted as a credit against the minimum wage. So that's an example of where you can actually dip somebody below the minimum wage. Under federal law, you can dip them below minimum wage by claiming a tip credit. That doesn't work in states like Minnesota. It works, I believe, in Wisconsin. I'm pretty sure in Wisconsin. Everybody wants to be a server, and maybe not, today, because of all the shutdowns of restaurants and bars and everything. But for the most part, if you're going to be a wait staff, like a server or something, you want to be working in Minnesota versus Wisconsin, because in Wisconsin they can claim the tip credit, I believe. In Minnesota, there's no tip credit. So Minnesota's got, it's like around $11 an hour minimum wage. Servers get that full. They could get $500 an hour in tips if they're so lucky. They're still going to get their $11 an hour. In other states, in most other states, you're going to be able to claim as a tip credit. Okay, so I guess I just tested myself. There are the actual definitions. It looks like I'm pretty accurate on what I just said there. The one thing, so when we talk about wages, we talk about the total wages, the all compensation paid. But the really important definition that we need to understand for this webinar and for the webinar next month, especially because we're going to do a lot of math next month, is understanding the regular rate of pay. It sounds simple. It's not. The regular rate of pay is, like it says, all remuneration made to an employee, but there are some exclusions, okay? So exclusions like, for example, 401k matches. You don't need to include, if you're matching an employee, let's just say 6% of their compensation, you do not need to take that 6% and then recalculate it back into the regular rate of pay. Now, we care about the regular rate of pay for non-exempt employees. And the reason is because if based on what the regular rate of pay is, that informs us of how much we pay in overtime. Because overtime is 1.5 times the regular rate of pay. It's not 1.5 times their hourly rate. If the employee is getting, let's just say $15 an hour, but then they also get a bonus based on productivity or sales or something like that, and they're a non-exempt employee, well, the bonus needs to be recalculated back into the regular rate of pay. So if they work more than 40 hours in that week, it's going to be 1.5 times the regular rate of pay influenced by the bonus. So it's not going to be $15 an hour. It's maybe with the bonus calculated in, it's $20 an hour. Obviously, 1.5 times 15 is a different number. 2250, right? Is a different number than 1.5 times 20, which is 30. So you got to pay the employee $30 an hour on overtime hours, not $22.50 an hour. We'll get into that math next month. But I want to give you a flavor of why regular rate of pay is probably one of the absolute most complicated and also important concepts that you need to understand with Federal Labor Standards Act, FLSA. Okay, methods of compensation. These are the general methods of compensation. This is how we compensate employees. Again, sounds easy. It's not always easy. Hourly rate. It might be a mix. You might pay employees a mix of hourly, salaried, commission, tips, and piece rate. Go for it. You can pay all of them. Hopefully your payroll software, I'm almost certain it will, but if you have payroll software, it should absolutely work to, within all of these as, compensation methods. So hourly employees, pretty easy, right? I'm making $15 an hour. I get paid for all the hours that I work. I'm a non-exempt employee. I'm an hourly employee. There it is. Salaried employees. Salaried employees tend to be exempt from overtime, not always. You could pay a non-exempt employee a salary. A lot of companies do it. For whatever reason, employees think that being on a salary has some sort of prestige to it. It makes no sense to me. That's not the only thing that doesn't make sense to me, but that makes no sense to me. Why, people think that it's, higher up the food chain in corporate America to be paid a salary doesn't make any sense to me. But that's how it is. So some non-exempt employees can be paid salary. Exempt employees can be paid salary. Outside salespeople could be paid salary. That's fine. We have to pay a salary, and we have to follow the salary basis test, things we'll talk about next month, with regard to the white-collar exemptions. Your administrative exempt employees, your professional exempt employees, and your executive exempt employees. We'll dive into those definitions next month. But those three categories, which are going to be most of, people on this call, most of your exempt employees who are not being paid overtime, they're going to be paid a salary because they fit into one of those three criteria, classifications. Administrative, EAP, right? They call them EAP. So executive, administrative, or professional. And you have to be paid on a salary basis test for all of those. There are a couple exceptions for like lawyers and teachers, but who cares about, at least who cares about lawyers? For the most part, for almost all your employees out there, you got to pay on a salary basis. You cannot pay an hourly, except to lawyers and teachers. You can't pay an hourly rate to somebody who you are claiming is an executive exempt employee and you don't want to pay them overtime. Got to pay them a salary. The salary has to be a minimum amount of now, as of January 1, of at least $684 a month. And it's not prorated. I don't care if they work part-time. It's $684. If you want to claim them as exempt, it's at least $684 a month, a week that you need to pay that person. You could pay people on a commission. Normally we see commissions being paid to salespeople. Outside salespeople, in order to meet the outside sales exemption, outside, not inside, right? Outside sales exemption, those people need to be paid primarily on a commission basis. So commission is a way. You could also pay a salaried exempt employee a commission. That's fine. You can pay them, tips as well. So you could do this, but commission is the way that we pay. Commission tends to be based on sales, based on revenue coming in, that sort of thing. Just realized I didn't turn my phone off, and oh yeah, no, I did. Okay, good. Tips can go to anybody. However, if we're going to claim the tip credit for our tip, it has to be a service-oriented job where the person is in direct service. It can't be house managers. It can't be back house managers. It can't be cooks. Some restaurants get around the whole tip thing by having the cooks deliver the food directly to the table. It's a nice way to get around that restriction. But especially in like a tip pooling type of situation. But tips are gratuities that are paid by customers to service professionals, and those tips are the property of the service professional. Tips aren't supposed to go to the company. They don't go to the company for distribution. They are the property. They are owned by the employee. Again, we'll talk about nuances and details of that next month a little bit. Piece rate is something that is more common in the manufacturing sector to motivate employees to produce things faster, right? So piece rate, anybody can be paid a piece rate. I could be paid, lawyers can be paid in any way, right? Because there's no salary exemption. But you could pay hourly employees a piece rate if you wanted to. TPS reports, right? I'm going to give you $100 for every TPS report that you produce. Totally fine. You could have a secretary get paid $5 for every phone call he or she answers. That's fine. Every time they open the mail, they get $10. Every time they talk to somebody in the office, they get $4. That's fine. You could pay them on a piece rate. You just need to define it. It needs to be understood. It should be in part of your offer letter. It could be part of or the entirety of the compensation that you pay to the employee. But a piece rate is just that. It is, you do this, this is how you're going to be paid. Now with piece rate, we still have to track time. Because the person's going to be non-exempt, we need to track their time. And at the end of the work week, we need to make sure that all that piece rate added up, divided by the number of hours that they worked, it was at least minimum wage. And that's how piece rate works. And if they work overtime, they're going to divide the whole compensation on the piece rate, and they're going to divide it by the number of hours, and you're going to figure out what the regular rate of pay is, and you're going to use that as the multiplier for overtime as well. So piece rate works well. It's just much more common in manufacturing, and I don't think it's as common these days as it might have been like 20, 30 years ago. Okay, so that was a mouthful. Let's look at some concepts. So non-exempt employees. So I'm going to repeat a little bit here of what we said, but that's okay. Non-exempt employees are entirely governed by the FLSA, right? That That's where all the FLSA stuff comes in. Got to be paid at least minimum wage unless you're a tipped employee in a state that doesn't have its own, that doesn't have a tip credit, but has a minimum wage, like Minnesota, for example. So you need to be paid at least minimum wage, at least $7.25 or whatever the state minimum wage is. You need to be paid in a legal tender. We normally call that money. That normally goes into like banks, but you could be paid on like a pay card as well. But you can't be paid in like company swag, right? Like that doesn't work. Employees need to be paid in a legal tender. They need to be paid for 1.5 times the regular rate of pay for all hours worked over 40 in a work week. If you could take away anything from this webinar, it's to understand that overtime rate is not just the hourly rate. the hourly rate of pay. It's the regular rate of pay, because for a lot of employees, they get other compensation beyond just their hourly rate. But that's what it is. 1.5 times their regular rate of pay. And then for all employees, you have to track, for all non-exempt employees, you have to track the time worked. Now, when we're looking at the regular rate of pay, right, so it's all remuneration that the employee receives, right, all remuneration except these things. And I'd mentioned the 401k example before. Here's a fuller list of all the things that we don't count in that regular rate of pay. And you need to understand this because we don't want to unnecessarily throw too much into the regular rate of pay, because if the employee works overtime that week, it's going to jack up how much overtime that we owe to that employee. So value of stock options. Everybody has stock options, right? I'm just kidding. So value of stock options, if you're lucky enough to have stock options, or unlucky enough to have stock options in the last 2 weeks, the value of those stock options, that's above and beyond. That's not part of the regular rate of pay. So when you collect your millions in stock options, we don't need to roll those back in to the regular rate of pay like we do, like commissions, for example. Expenses. It could be like driving expenses, like reimbursement. And when I say expenses like reimbursement, that's reimbursement up to the federal level tax deduction level that the federal government comes out for, like the per mileage level that we're all probably fairly familiar with. I don't even remember what it is right now. Off the top of my head, maybe like 57.5 cents or something like that. Maybe that was last year. That might be 2019. But in any event, beyond that, so you don't have to count as a regular rate of pay. If you're reimbursing somebody for like driving, for example, up to the federal deduction limit. If you reimburse beyond that, and let's just say you give the person $1 a mile, then it's going to be remuneration. It's going to be above that federal level, and so then it's going to be considered income. And again, I'm not an accountant, but I think you have to report that as a W-2 income. Again, don't quote me, but talk to your accountants about that. I'm fairly certain that's how you do it, and then you have to include it in the regular rate of pay. Premium pay, if you are doing like hazard pay or you're doing like holiday pay, something like that, but some sort of or like second shift or third shift pay, some sort of premium pay, you don't get double taxed on that premium pay. So we don't have to put that back into the regular rate of pay. That concept gets a little complicated, so definitely reach out to me if you have any questions on it. Discretionary bonuses. This is a big point of contention. What is a discretionary bonus? Like it says, it's got to be wholly discretionary. If you give the same bonus to employees every year for several years, there's a real serious legal question whether that's discretionary anymore. You can call it discretionary all you want, but if the employee comes to expect it, and if there's communication around like, well, keep doing a good job and you'll get this discretionary bonus, then it's no longer discretionary. It's expected, and it should be part of the regular rate of pay. Caution on giving the same type of bonus or the same amount of a bonus to employees at about the same time or on the same schedule for many years in a row. Like I say, I think the discretion then gets watered down. It wears off. Gifts, if you companies give gifts all the time, right? So it could be like a holiday gift. It could be an anniversary gift. You don't have to calculate the $15 pen that you give to somebody for 15 years of work. Congratulations. You don't need to calculate that $15 pen back into the regular rate of pay. Payments in the nature of gifts, payment for no work. This is the big one, paid time off. If you're paying somebody to not work, which is called paid time off, then it's not, quote, work, and we don't have to put that into the regular rate of pay, and we don't have to calculate it into the calculation for overtime. Profit sharing, we all have profit sharing, right? So profit sharing, again, kidding, profit sharing does not go into regular rate of pay. What is compensable time? Compensable time is training time. Anytime the employee is training, And at your behest or for your benefit, I don't care if the training's in Hawaii. That's awesome normally to be able to travel to Hawaii for training. If it's for a non-exempt employee, it's hours work, right? So this is like, I'm doing little air quotes, hours work, like working or quote working time. Orientation. If there's orientation, or onboarding, I guess I've got to get more 2020 on this. Actually, onboarding is probably very 2019. So onboarding or orientation is working time. You need to pay. That's compensable. That's why we do the W-9 or W-2. That's why we do the I-9s before, because orientation, onboarding is the employee has already started working, right? So you gotta pay them. That's working time. One thing I'll mention, just in case I don't mention it, can you pay at a different rate for all of these types of things? Like if you want to send somebody to Hawaii to do some training, could you pay them at minimum wage? Absolutely. You just need to notify the employee in writing of the change to their hourly, their terms and conditions. Notify them that training time gets paid at minimum wage. Enjoy your flight to Hawaii at $7.25 an hour, even though you might normally make like $20 or $30 an hour. You can absolutely do that. You can have, just like you can have different wages for different shifts. You can pay second shift more than you pay first shift. You could pay people extra to work on Saturdays. You can change this. There's no reason that you can't. So you can put a bunch of different levels. You might have somebody do two different jobs. You might have somebody who cleans the office, and when they're cleaning, they make $10 an hour. And then the rest of the work week, they are working in some sort of professional capacity, and they're making like $30 an hour. Absolutely do that. If they work overtime, you're going to have to blend the two rates. That's more complicated. We'll talk about that next month. But you need to take the weighted average between the two, multiply it. That's the regular rate of pay, and then multiply it times 1.5. Voila, you've got overtime calculation. So on-call time, cleaning up time, donning, doffing time. These are all things that are done toward the waiting time that's required there should be a T there, to be on the work property, and then rest periods of less than 20 minutes. These are all times that are, quote, working time, end quote, and that need to be paid, compensated for the work. Let's dive into some of these a little bit deeper. What does it mean to be on call? You do not need to pay employees to be on call. You don't need to pay employees to be on call. Employees all think they need to be paid to be on call, most employees. They don't. Employees don't need to be paid to be on call. When they substantively respond to being on call, or if being on call means that they are so restricted geographically, like they need to respond and they can't enjoy life because they can't they've got to be within like 5 minutes of the office at all times while they're on call, then it might be working time. But just being on call, carrying a pager, having your phone number available, even checking in, calling in for like 1 or 2, like a de minimis period of time, not compensable. It's not, quote, working time. No working time. If it's so unduly restrictive that they can't enjoy life, then it is working time. If you're in a major metropolitan area and you tell the person, you've got to be on call, if we call you in, you need to be here within half an hour or within an hour. Well, in the Twin Cities or in New York or Chicago or Dallas or Austin or LA or any other major metropolitan area where most people live in this country, you can enjoy all of your life, mostly. You can enjoy your life being within like half an hour of having to be on call. Because you can go to the movies, you can go to the grocery, all these things, when they're normally open. You can go around, you can see your family, you can hang out. You are not restricted. And so you can enjoy life. Therefore, it's not, quote, working time. Okay. People all think, like, just because I'm on call. Now, for morale purposes, you might want to pay people for being on call. That's a totally different question, but it's not working time, and therefore it doesn't need to be included in the regular rate of pay. So even if the person's on call and you're paying them, let's just say you give them $100 for being on call that week, you don't need to calculate that $100 because that's like premium pay. That's premium pay. You don't need to calculate that $100 into the regular rate of pay for calculating overtime. Okay, that's where the premium paid. That's why this is important to understand. Same with waiting time. Just ask yourself these questions. And the key is for all of these: can the person enjoy themselves? So if I'm waiting, if I'm told to like be on call, which is another like waiting time on call, do I need to be? That's fine. Then if I can enjoy myself, then it's not going to be. I'm not going to be. It's not, quote, working time. If I'm told to report to a place and then I have to wait for like somebody to come and pick me up, boom, that's working time because I've been told to report to like a work site and then I have to wait. So then I'm actually working even though I'm just, twiddling my thumbs waiting around for the car to come and pick me up, just as an example. So waiting time is often compensable working time. We just need to understand the circumstances. Trainings and meetings, most of the time, especially if they're done for the company's benefit, certainly if they're done at the company behest or request, it's going to be, quote, working time. Is it voluntary? For example, we don't want to mandate that people come to the basketball game that the company's throwing or to this certain meeting with clients or like a holiday party. We don't want to mandate it because once we mandate it, then it's work. Then it's working time. Is it voluntary? Is it directly related to the job? We have to ask ourselves all of these sorts of questions to understand whether or not it's related, whether or not it's working time. And so, anyway, there's a lot of questions. You can see them all right here that we have to ask. And there's no just like single question that we ask, but we have to understand all of them. Travel time, commute time is not working time. It's not, quote, working time. We don't have to pay for commute time. It is important for you if you have a job, an employee in a job, where travel is part and parcel of the job. Some sort, I don't care if it's 5% or 100% of the job. You need to define in the job description what the expectation is. If you say that you're expected to commute or travel the entire state of Texas, that's your territory. Like you might have to go to all these offices or locations throughout the entire state of Texas. Then the entire state of Texas is technically your commute time, your commute zone. If you always go to a specific location, office in Dallas, and then boom, you're told that you've got to go to Austin, you got to pay that person to go to Austin. That's travel time. And if they're traveling outside the workday, you're going to have to pay them to travel to Austin outside the workday, whether they're flying or driving. There's some exceptions for flying if they can relax and if it's outside the workday. So if they're up in the plane and they're on Southwest Airlines and they're going from Love to Austin and it's outside the work days, the work time, like 8 to 5, and they're flying from like 7 p.m. at night to 8 p.m. at night because it's a short flight, you don't have to pay them to relax on the plane. So if they can relax on a plane, if they can relax on a bus or a train or the backseat of a car, then and it's outside normal working hours, you don't need to pay the person. If it's during the work days, the typical work days, 8 to 5 p.m. and they go to Love Field and they hop on the plane and it's 3 o'clock in the afternoon. Well, that's within that 8 to 5, right? You got to pay them. So you got to pay them for the full day. But in that situation, the person always works in Dallas. Their regular commute is not to Austin. Some jobs, that might be going to Austin, going to Fort Worth, going to San Antonio, going to Houston. That might be part of the job, in which case for that job, for that person, we want it reflected in the job description. The whole state of Texas might be their commute. And so we need to understand jobs, and we need to understand the job description and have the job description reflect what the expectation is for commute distance. Again, more complicated issues on that next month. Meals and rest breaks are not paid. You have to, but in order to not pay somebody for a meal or a rest break, the meal or the rest break needs to be less than 20 minutes or less than 21 minutes. Technically, the regulations say 30 minutes, but in practice, the Department of Labor doesn't do anything about it if it's 20 minutes or if it's more than 20 minutes. So that's why we tell people if they're not, again, these are for all, we care about this for non-exempt employees, right? Because salaried exempt employees, most of your salaried exempt employees, they're getting a salary. So we care about deducting from non-exempt employees because non-exempt employees are only entitled to the time that they, quote, work. That's why if you send somebody home because you don't have work for them because of coronavirus, you don't have to pay them if they're non-exempt employees. Now, the federal law that just got passed in the next 14 days, that's going to change. But non-exempt employees are only entitled to time that they can, quote, work, that they are, quote, working. If they're able to relax, and relax means 21 minutes or more, then they can relax. You can deduct the time that they relax for a meal or a smoke break or whatever it is. Even if they go to have a meal and they clock in and they clock out and it's for 19 minutes, you got to pay them. You might be angry at them and you might discipline or talk to them about it, but they just gamed the system and they're going to get paid for the full 19-minute break. If they clock out at 21 minutes, you don't need to pay them. And so, again, gaming the system. We want to watch out for employees doing that, especially if you're, and we have to be careful that when they clock in and out, if your time management system is counting by the minute, we need to make sure that you're not deducting for every minute that they take. If it's like if it's less than a 21 minute, if it's 20-minute break or less, we want to make sure that you're not deducting that 19 or 20 minutes. Rounding. The Department of Labor allows for rounding. Now, generally, you're supposed to round up and down equally so it all balances out. But there is a rounding. This is why when somebody works, that you can have a 15-minute time management clock, right? A lot of companies have gotten away from 15-minute time management clocks just with, more sophisticated time management software out there. But can you do a 15-minute rounding? Absolutely. We just need to be even on it. So we can't always round to the employee's disadvantage, right? So if your time management system is set up so that you're always rounding down, so if the person is supposed to work from 8 to 5 and they clock out at 5:05 and you round down to 5 o'clock to make it even, then you got to do the same if they clock out at 4:55, right? If you're clocking out at 4:55, you should round up to 5 o'clock. In that situation, if they're clocking out at 5:05, you need to round down. So it should ultimately balance out. If you see the employee gaming the system, which employees always do, and they are clocking out early every time, knowing that they're going to get rounded up, so they get a free 5 minutes, that's a management issue, and you should talk to them about it. Time recording. For non-exempt employees, this is what you need to record. Now, again, your software is probably handling a lot of this, but these are the records. You got to have these records, all of this information on it for at least 3 years in length. And why 3 years? Because that's the period of time that you can get sued under the federal law if you're a willful violator. 2 years if you're not. So if you have screwed up and you're not paying minimum wage or overtime, and then you fix it, count the days until that 2 or 3 year period is over, and then you can have your own little party that you got away from the statute of limitations, because they can only bring a lawsuit against you at the most 3 years from the time of the violation. This is all the stuff. All of these items are what you need to have on, for all of your employees. Deductions. Deductions can come in a number of areas. You can deduct from benefits. You can deduct for tip credits, voluntary assignments. In writing, most states require in writing voluntary assignments, like, take, I take a loan from you, from your company, and I voluntarily assign that you can take $100 out of my paycheck until the loan is paid off. Something like that. Voluntary assignment. Garnishments coming from outside third parties or court orders, like child support, that sort of thing. Uniforms, you could have a uniform deduction. Again, look at the state laws to make sure that we're not dipping below minimum wage. And some state laws also have restrictions on doing deductions for garnishment, for uniforms. State laws also have garnishment reductions where you can't garnish more than like 25% of gross wages. But anyway, child support often states allow for more than that, more than the 25%. Loans, wage advances, taxes, just heads up, we all pay taxes or should. Those come out. Insurance premiums that the person's assigned, group plans, 401k, under other benefits, jury duties and fees. A lot of states allow that if the employee earns jury duty fees, like they get their $30 or whatever for being on a jury for that day, that you can actually deduct that amount, that the money that the employee received from jury duties, you can deduct it from their wages, or you can make the employee come in and give you their big time jury duty pay. And you can only do that when you're actually, if you've decided, whether it's because you're legally obligated to do it, or most states don't legally obligate you to pay for jury duty time. Federal law doesn't, for example. So you can only do it if you're, ask the person to give you the jury duty money if you decide to pay them for the time that they're on jury duty. But jury duty is technically, quote, not working time, right? It is not working time. So exemptions. The first three are the most common ones that you're dealing with: professional, administrative, and executive. We will dive deeply into those next month and talk about them. Those are the ones that you need to pay a salary, of course, except for the lawyers and teachers. Then there's commissioned outside sales, but then there's a whole list of people that you might not really think about as being exempt from either the overtime provision or the minimum wage provision, or both, for a lot of these. So for commissioned outside sales, again, outside sales, not inside sales. Inside sales people should be what we call paid on an hourly basis and paid overtime. A lot of companies screw that up. Outside salespeople should be going outside, should not be stuck in your office, and should be outside generating money and sales for the company. Retail, there is, however, commissioned inside sales in a retail or service establishment. I always think of like Ed Bundy as, from Married with Children from back in the 90s. Maybe it was 80s, but I think it was 90s. So Ed Bundy, he was a shoe salesman. So a shoe salesman would be an example of somebody who is in a retail or service establishment, and he is being paid solely commission on his sales. And again, most of the compensation has to come from commission sales. It can't, anyway, there's some rules around this. Professional employees, back in the 90s, this was passed, were professional employees, even if they're paid on an hourly basis. I think it's like $27 and change at least. They are exempt, certain professional computer employees anyway. DOT drivers, everybody understands that we don't pay overtime to DOT over-the-road drivers. Farm workers, taxi drivers, domestic live-in employees, and then some, potpourri ones that are just more interesting than anything that I threw out there for you. Other stuff on exempt employees, you don't have to pay. Again, for these categories, you don't have to pay minimum wage and overtime. So babysitters, heads up. If anybody knows of a babysitter that actually charges less than minimum wage, well, let me know, because I found that to not be the case. But anyway, seasonal amusement park employees, farm workers, computer professionals, outside sales, professional administrative exemption. And I'm looking at that list right now, and I'm thinking, I think except for the computer professional, I think I have at some point in my life worked in every single one of these categories. So I recall detasseling corn as a kid, definitely not being paid minimum wage. So it was a lot of very hard work, not being paid minimum wage. And yeah, and then so I think I've worked at in all these categories except for computer profession as a computer professional. So for these people, you don't have to track the time, but you could choose to track the time if you wanted to. If you want to have an exempt employee, you can absolutely choose to track the time. Okay, we've got a few minutes, surprisingly. Somebody asked a question. And the question is, okay, if we've closed our doors temporarily, I don't think this person is alone in that situation, and they're paying the staff 60% of their hours, can we reduce the salary staff by 60% if they're not working? This is a really great question. And in all honesty, I back in the Great Recession days, like back in 2008, 2009, 2010, I had this question all the time. So the whole deal with the salary exempt. So let's just hourly employees, we don't care about them, right? So we're talking about salary exempt. We're talking about your professional, your executive, your administrative employees. You need to pay them on a salary basis, and that salary basis needs to be at least $684 a week. At minimum, $684 a week. Could you pay them more than $684 a week? Yes, absolutely. You could pay them more than $684 a week. But could you pay them less? No, yes, but then they're not exempt. Okay, so the deal is, can you, in times where like you've shut down, can you lower their salary? So other things you need to know. And again, next month. This is more for next month, but because of the coronavirus emergency, let's talk about it. If the salaried exempt employee works at all during that week, they are entitled to their entire weekly salary, okay? If they work 15 minutes for you, if they worked earlier this week, and then you've shut down like today, and they are entitled to their compensation for the entire week, full salary, cannot reduce it, because you've shut down, you're not letting them work. Next week, however, if you totally close your doors and your salaried exempt employees are not working at all, they are not entitled to their salary at all. You owe them zero. If they work 15 minutes next week, you owe them their entire salary. But if it's absolutely shut down, whole week, the whole work week, however you define the work week, they don't get anything. And so if you're going to lower their salary, you can, because you don't owe them anything. You're basically just paying them kindness money. It's really a form of paid time off if you're lowering their salary. The more complicated question is, well, what if we just cut back time and we just have people, our salaried exempt employees, come in half-time? Can we lower their salary commensurate with that? Generally, no, because again, they worked it all. They've got to get paid. However, you could strategically lower their salary for a long period of time, with just like you can lower anybody's salary, right? Because it's at will. And so you can lower anybody's salary, and as long as you notify them in advance before the work week, and they still come in and they still do their work, even if it's 50% of their work, they are accepting the terms. So yes, you lowered their salary, you lowered their rate. But it can't fluctuate, because a salary, the whole idea with the salary basis test is that it's a guaranteed minimum amount of at least $684 a week. So even if it's like half, say this person's still making $684 per week, and it's still 50%, and they're working 50%, and even after you want to reduce it by 50%, it's still more than $684 a week. Let's just say it's $700 a week because they were making $1,400, and you want to lower them down to $700 a week. You can do it, but you better not make that change again like a few weeks later. That needs to be a longer-term change. Generally, from about 15, 20 years ago, it's been so long since I've been talking about these issues. I used to talk about this during the Great Recession all the time. 15, 20 years ago, the Department of Labor came out with some guidance, an opinion, and they said, look, we're not going to have a problem with an employer if, under these types of circumstances, they fluctuate their salary a couple times a year. So that's about That's about the most I would do. So if you're going to lower the salary, I don't think I would do it more than, I wouldn't fluctuate. I wouldn't go back and forth and then go to 75% or back to 100%. I wouldn't do those changes more than twice in the next year. So I'd be mindful of it. And I would invite anybody on the My HR Genius program to reach out, because there's more complicated issues around these with paid time off and the new coronavirus law. But that's generally how I look at these things. Okay, great question. Time's up. Welcome anybody to reach out to me during this difficult time. Thompson & Co. is here to strategically advise you. We have been going gangbusters helping companies out and organizations. So I invite all of you to reach out to us and for assistance. Next month, assuming the plan is to have a webinar. Watch also for the emergency webinar that we'll be putting out if you're on the My HR Genius program. And then next month, we'll talk about a lot of these issues and get more complicated on these wage and hour issues. Until then, I hope everybody takes care of themselves and their families, and call with any questions or email. Thank you.